Shalom, brothers and sisters. Once again, it's the boy, it's the brother Tazadak, coming at you through the spirit of Yahweh B'Hashem Yahweh Shah. I wanted to talk to you about averment of jurisdiction. Does your court have jurisdiction over you? Most of these courts, when you enter into them, they're practicing colors of law. And make no mistake about it, these attorneys are not going to tell you this. The judge is not going to tell you this. The court is not going to tell you this. So, you want to challenge them. So, in my last video, I started talking about writs of discovery. And what that is actually you're asking for obtaining information that they claim they have against you. Do they have jurisdiction over you? Or are you consenting and giving them jurisdiction over you? You want to find this out so you can make a lawful defense, to prepare for your defense. So what we want to talk about now is an averment of jurisdiction. What is jurisdiction, first of all? Because many of us may not know. Jurisdiction, and once again, I do not offer legal advice. This is not legal advice. If you need legal advice, seek yourself a lawful attorney and please be advised. This is for educational, information, and entertainment purposes only. So jurisdiction is the legal power, or right, or authority to hear and to determine a course or courses. Also, jurisdiction is the authority of a sovereign power to govern or legislate or control. And jurisdiction is also a sphere of authority. So what's an averment? Because we're talking averment of jurisdiction. It derives from aver. Well, aver means to vouch. It's a vouch, or it's to verify, or it's to prove, or to justify. Aver is also to affirm, or it's to declare positively. So an averment of jurisdiction would be to verify jurisdiction or have them prove jurisdiction. So we say an averment of jurisdiction. Does the court have it? Now, court, what is a court? I know most of you know what this is, but a court is the persons duly assembled under the authority of the law for administration of justice. That's what a court is supposed to be. So, you have what is known as the tribune, and now in Roman history, it's an official or magistrate whose specific function was to protect the individual plebeian citizen from the arbitrary actions of the magistrates. So, we want to do an averment of jurisdiction to ensure that this court has jurisdiction over us. Now, all judicial powers is vested in one court. That court being the Supreme Court. Now, the Congress may delegate such powers with a delegation of authority order. D-O-A-O. D-O-A-O, Delegation of Authority Order. So, the proper protocol in a court should be as follows. You establish status, or you in appropriate persona. What is your status? What is the judge's status? Who are you? My honor, who are you? Does he have standing? What are your status? What is your social standing, brothers and sisters, in the community? Are you a breathing, living, thinking being of flesh, or are you a corporate fiction, or are you a corporate entity, or are you a corporation, or are you a straw man? What is your status? What is the judge's status? Who are you? Are you a fictitious, dead person? because the corporation is dead. Therefore, the corporation cannot speak for itself, so the corporation needs a representative to speak for it. The second thing is jurisdiction. Venue. Jurisdiction / venue. Where are you? Are you in a lawful court or a tribunal court? Does that court has jurisdiction over the person? Does that court has jurisdiction over the matter, the subject matter at hand? Does that court has jurisdiction over the territory? So that takes us right back to status. Does that court has jurisdiction over the person? Which actually determines, does the court have jurisdiction over you? Your status determines that. Does this court has jurisdiction over the subject matter? Does the court has jurisdiction over the territory, meaning the territorial jurisdiction over the place where the alleged crime or civil violation occurred? And does the court have the capacity to rule such? Under whose authority is that court acting? Under whose authority is the judge acting? If you allow the court to pass status and jurisdiction / venue, then the court moves to what is known as adjudication. So we have 1, established status. We have 2, to prove jurisdiction. And we have 3, is adjudication. So what they want to do, normally you go into a courtroom, you don't prove status, you fall under their jurisdiction, so they skip jurisdiction and they jump right into adjudication and start charging you. You're being charged with this, and you pay a fine, you do some jail time, or so on and so forth, because you're not challenging the court's jurisdiction and you're not in your appropriate persona. So they adjudicate you, and an adjudication is a determination of the penalties and punishments, sentences, including the fees and the court's fines. This is why you must ask for a delegation of authority order, brothers and sisters, and you ask for it in written form and to be placed on the record, for the record, and enter into the record as evidence or proof of authority. You must do this. This determines the jurisdiction of the court. If they fail to produce this, brothers and sisters, they don't have it. Cut and dry, they don't have it. If they fail to produce this, they don't have it. And technically speaking, the matter is closed because they don't have jurisdiction over you. But your consent, and you will give them jurisdiction over you. As soon as you make a plea, be it innocent, guilty, or no contest, you put yourself under their jurisdiction. How do you plead? Will the defendant please rise? How do you plead? You're being charged with so on and so forth. How do you plead? You respond to that, you're going under their jurisdiction. Well, you're not the defendant. You're the living soul. I'm his authorized representative. I demand a trial in common law court. You issue your delegation of authority. You bring that in with you. You have this delegation of authority. You challenge the jurisdiction of the court. Always ask for a delegation of authority, especially if they have you in lieu of the fact that they may have you in lieu. So always challenge the jurisdiction, because most of the times they're lacking jurisdiction of authority. You should also, for the record, ask for the judge or the magistrate's oath in office. And this is the agreement that they swore an obligation, and they've actually taken an oath to uphold and support the Constitution. All authority, once again, brothers and sisters, derives from the Constitution. All authority is derived from the Constitution of the Federal Republic. All authority. So you ask for this in what is known as a writ of discovery. So you ask for this delegation of authority by way of a writ of discovery. You're asking for a delegation of authority order that is a request known as an averment of jurisdiction. An averment of jurisdiction. So, most of you don't do this. The judge will ask you, you won't challenge you. Most of you go into the courtroom, or you hire an attorney, then you go in you as a dummy because he's speaking for you. He's not representing your case for the first time. He's representing you. Well, a representation is not real. A representation is not real. You're not speaking for yourself. So, or the judge may ask you, do you want to pro se? And when he says pro se, what is it? What is pro se? Well, according to Black's Law's Dictionary, 4th edition, pro se, Black's Law's Dictionary states, is to proceed for himself, on his own behalf, in person, to proceed, to prosecute, pro se, to prosecute. I advise all of you to submit all the paperwork in propria persona. All of you. Try to be in propria persona when you submit your paperwork. And if you are in pro se or prosecuting in colorable courts, this is not good. So many of you confused and you think that because pro se also means to proceed, you think that it's good to proceed. It's not good to proceed because you're proceeding in a colorable court. You proceed under their jurisdiction willingly. If the judge say, are you in pro se? And you said yes. When he asks you, are you in pro se? The answer had better be no. Remember, before adjudication, which is the sentencing of these penalties and punishments or imprisonment, which is also known as a remedy, there should be an injured party, brothers and sisters. There should be an injured party. For you to bring remedy about. And you got to keep that in mind. There should be an injured party for them to have remedy. So your accuser must also be present for the record in the court. For the record, I would like to question my accuser. I would like to face my accuser. Is there an injured party? And ensure these things are presented before you proceed, brothers and sisters, before you are in pro se. You do not want to be in pro se. Do not proceed in court in pro se in a colorable court that do not have jurisdiction over you. You're giving them jurisdiction over you if you proceed in pro se. If they don't have jurisdiction, they cannot proceed unless you consent. If they do not have jurisdiction, they do not have the authority over you to proceed unless you consent and proceed under their judication, under their authority. So if you are in pro se, you're going to allow them to adjudicate you. Therefore, ask for the record, both for the oath and office, for that said court, and you ask for that delegation of authority, the authority order for that said court. So once the issue of jurisdiction is placed before the court, it must be satisfied, brothers and sisters, before the court can proceed. Now you can like and understand it, believe it or not. Once the issue of jurisdiction is presented before the court, that order of jurisdiction, if you do it right in the affidavit of fact, it must be satisfied before they could proceed. So, in my conclusion, you're going to ask for what? An averment of jurisdiction. So, what you want is a writ of discovery, and you're asking for a delegation of authority order. This request is known as an averment of jurisdiction. Once again, my name is Brother Tazadak, and I would like to say Shalom, Shalom. I hope you gathered something from this.